But once you've made the decision, pick your partners and move forward expeditiously, thoughtfully, carefully, but quickly, because a short delay now could lead to a several-year delay down the line.
异国寻梦想，投资要设防。欢迎来到美财帮，我是主持人 Andrew。我们书接上回，继续我们的提问。And back to last time we talked about the rescue projects.
Right.
We used a term like the good faith.
Good faith.
Okay, let's go back to that because how does a good faith investor determine?
I'm gonna talk about a little bit, but correct me if I'm wrong. But the good faith investor should be okay if their previous project got issues, but any fraud or any failure of that project has they're irrelevant to the investors themselves. It should be like the term of good faith investor. The knowing participant on the other side, which is he or she knows that this project is going to doing something wrong, fraud actions, but she or he still make the investment or still join this our RC's project. That should be the way it is. But I'm pretty sure they have pretty more clear definition.
Because Gary used to be the chief.
Exactly.
In the USCIS. So in practice, how do you make a judgment that it is a knowing participant or not?
So let me take a step back on this. The good faith investor provisions come from the 2022 reform law. And what they say are, if you have a regional center that is terminated or debarred, and you are a good faith investor, you have options to continue your immigration journey through the EB-5 program. Previously, an investor who, with full good faith, without being a knowing participant, any problems in the regional center, but if the regional center had a problem, might lose their opportunity to continue to get a green card to continue through the EB-5 process. So like grandfathering, the good faith provisions are another investor protection from the 2022 law, an important one. Now, it's perhaps more important that you invest in a regional center in a project that doesn't have problems. And that's where the due diligence process that your broker-dealer assists you with, and your immigration lawyer might be a part of, is so very important. Because the best option is to have a project that succeeds. Now, if you don't, and your regional center is terminated or debarred, then the Immigration Service would assess whether you're in fact a good faith investor. Now, we don't have regulations on this, and we have actually very little guidance from the agency. But I think it's exactly what Gino said, is were you a knowing participant, or was what the regional center doing something completely separate?
I think that's right. You think good faith investor, what's the other side of that? It's a bad actor.
Bad faith.
So who's taking the bad action? It's typically within the regional center itself or within the context of the deal. And a lot of times in the past, investors had no idea what was going on. And so as an agency, they do not want to punish investors who were trying to do the right thing because of the bad acts of some other individuals or organizations. And so really that's where it stems from. And I think it's great to have that lifeline available for good faith investors, which led into ALC establishing rescue projects, opportunities available for troubled situations where good faith investors would like to move forward.
Speaking of that, so I have a question. Does the grandfathering clause affect the rescue project? Or let's say if the program ends on September 30th, 2027, are those rescue project investors going to be affected?
That's a great question. Now we're getting really advanced, right? From a legal theory standpoint, I think that those investors would be okay because they started the process long before the grandfathering date. And what the rescue project opportunities do is they allow someone to continue on that same journey. So you're not starting over, it's a continuation. So I think you should be safe, yeah.
But suppose if a project failed without the RC termination, are they still be protected?
The good faith investor provisions specifically require regional center termination or debarment. So without those actions, an investor may not be able to take advantage of the good faith investor protections and the options available to continue the EB-5 process. This is something you'll want to work closely with an immigration lawyer on because, and I've seen cases like this and in my discussions with other immigration lawyers, not ALC projects, but other projects, where there were bad actors involved, but the agency hasn't taken that step of termination or debarment. And the lawyers are put in a position on behalf of their clients of trying to get the agency to take that action so that the investor, immigrants, can themselves have that protection. It's a very challenging situation. And we do need more guidance from the agency and the agency to take action appropriately against regional centers that are bad actors.
But last time when we were here, talk about the rescue projects, Andy was here. Your colleague.
Yeah,
okay.
Yeah, of course.
We discussed a little bit about the reinvestment amount. And our conclusion was the rescue investor must match the minimum requirement, which is $500,000. However, this morning, I told Gilo already, this morning when I was going through the official website, it is clearly mentioned that we have to make the investment up to 800 grand. So which definition is correct? I'm kind of a little bit confused.
I think we still believe there is not guidance from the agency on this that makes clear the answer. But I think that what we've our analysis is that the people have to comply with the investment levels at the time of their initial investment, the time of the initial filing, so that 500,000, if you're a pre-RIA investor, is where you would need to be.
Just try to clarify another definition about at risk, because by law it says the investment must be at risk to generate the return of like profit. That costs at risk. My understanding was, personally, I thought the at risk, this term is equal to sustainment. Do you think my understanding is correct or not?
They're very closely related, but I think at risk is very clear. It's articulated in the documents. So as you go through the process, one of the first steps when you work with a regional center is to sign what they call a subscription document. And that's committing your capital to the project, meaning that you lose to a certain extent control of that capital, and it's at risk of loss. You could lose all of your funds. And that's really important to make sure at the outset that the documents explain that. The sustainment period is different. That is the minimum amount of time that the investment must be within the project, which is currently at 2 years. So a little bit different. At risk is yes or no. It's a yes or no question right at the beginning. Sustainment period is how long your investment is tied up with the regional center, and that's for you and the regional center to negotiate.
But I would say that you're right to think about it as connected concepts.
Yeah.
Because as Chris said, it's investment must be sustained at risk.
Yes.
And so they really are different, as Chris pointed out, but interwoven.
So to be precisely, currently by law, every time when we mention this 2 years, that's sustainment.
That's sustainment.
That's not at risk.
At risk has to be there, yes or no? Sustainment at least 2 years. Yeah.
And I would also say most ALC projects have a 5-year duration to them. And so investors should be aware as they go into the program to think that it's going to be roughly a 5-year process. Now, it turns out that between the amount of time it takes for source of funds, the amount of time it takes for the petition to be approved, the current time it takes to be scheduled for consular processing or adjustment of status, that whole process may end up being roughly 5 years in any event. But most ALC projects are going to have a 5-year duration. And so I would always say to investors, consider that your money will be tied up for 5 years. Consider that if we started Today, it's going to be a roughly 5-year period, 5-year journey.
Yesterday, when we were discussing about the good faith, you mentioned a legal terms called material change in this session. So I'm sure you have some questions to Gary and
Material change. Basically, there's a paragraph, which is the USCIS law on the USCIS website, saying that if you after investor get their conditional green card, so they can pretty much move their investment into a new JCE using a new job creation that would not trigger the material change. But if you that's basically, I use that clause a lot when I talk to the potential rescue investors. For the good faith investor, I think we're talking about the subsection M, which is mentioned from the termination notice. Recently, we got a lot. But those are a little bit different.
You know, I think when you consider material change in the investment, it's really about protecting that at-risk requirement, right? You don't want to be able to pull or have an situation where an investor can pull their investment out, eliminating the at-risk concept. When we start talking about subsection M, where there's a situation where you've got a good faith investor, maybe some bad actors, regional centers terminated, the agency has said that if you need to make those moves to move forward in the journey, it will not constitute a material change in the way that it normally would. Because in that situation where someone's got to go forward with a new regional center, forward with a new NCE, they have to make that change. And so it's under subsection M, you've got that protection.
Chris, wouldn't it also be the case that material changes might happen and might require an amended filing when something changes with the project?
That's right. You know, of course, as you move forward through this, there is a process involved. And so one of those key steps is making sure that you notify the agency through an amendment on your 526E. So that's very, very important.
if we change a perspective, I mean, let's talk about in the EB-5 application life cycle. The RIA, which granted from 2022. Let's, for example, from the I-526E to 485 to 829 in the whole life cycle, what has been changed and what is improved for the investors?
Well, I think post RIA, it's improved quite a bit, particularly if you've invested into either rural or HUA. I mean, those have moved at a pretty steady place or steady pace. So I think, one, the efficiency has improved and there's been more visa availability. So that's a huge difference overarching everything. One of the big differences with the new program, once you start thinking about the 485, is concurrent filing, meaning that
that's a good term.
if you file here in the United States, you can immediately get temporary work authorization, allowing you to remain in the United States while your EB-5 application is pending. That's a game changer for a lot of families.
And Gary, do you have anything to add on?
Only that, I'll just say it a little differently. The concurrent filing means you get the rights and benefits of someone who successfully completed the program while you're going through it. And so, as Chris said, it was a game changer. I think it's the right word. It's a tremendous benefit, like grandfathering, like the good faith investors. These are benefits and protections in the 2022 law, specifically for investors.
For those kids who have the age-out potential risks, if they do the concurrent filing, they file their I-485, using the final action date chart, so their age gonna be locked, right? What do you say? Because this gets pretty.
That's a good question.
This gets it's like a law school exam.
Yeah, right.
This gets extremely technical.
Yes.
And we actually don't know the answer if someone files and then there's retrogression. We don't exactly know how the agency is going to handle that. So one way to do it, though, and this is just something for people to consider, is to make the child the principal investor. And then the child would not be at risk of aging out as the principal investor. But it really depends what people's goals are for the program, is because many people, I think, do the EB-5 program specifically for their children, and they're perhaps less interested in immigrating to the United States. And if that's the case, they might want to consider having the child be the principal.
Seriously, I got a question from the parents from Shanghai last night. Because their child is already like 18 years old. It is risky. I suggest to use your son to be the applicant. But however,
Perfect answer.
Yeah, but however, do you have any other opinion towards to this? Because basically, after the RIA is granted, do you think we have a huge improvement on that?
Unfortunately, the RIA, the 2022 law, did not change the rules with respect to age out. And the law that governs that, the Child Status Protection Act, CISPA, we call it, is an overly technical and insufficient law, and it's unfortunate. But the answer, the way to address that risk and overcome it is to have the child become the principal applicant. And so your advice was exactly right, Andy.
Okay, let me put it this way. Suppose you have a son, 18 years old. What will be your decision? I mean,
I would say, son, fill out the application.
okay, that's crystal clear. Thank you very
That's the
much.
safest.
But that is the safest for sure. But I think it's really the question is, what do you as a family want, right? If you're happy living in China or Taiwan or Hong Kong, and you want the opportunity for your child, then what Chris said is the answer, and what you said is the answer. Have that child become the principal applicant. If you all want to be together here in the United States, then it's a different kind of analysis.
It was a real scenario. I didn't try to make a question.
Yeah.
That was what happened just last night. Okay. Anyway.
What would be your answer for your child?
I think Andy will make 2 investments. One for him and one for the child. That covers everybody.
How brutal. That's a second degree murder. So the next question will be the post-2027 scenario. Why are you so confident that the whole backlog will be cleared up in the next 2-3 years? Because as Gary just mentioned, in the future, the reserved and the unreserved allocation, visa allocations might not be that important, right? Could you please give us a wrap up?
Right now, we're seeing every year of the 10,000 visas used, most are going to the unreserved categories from those cases that are roughly 10 years old. And we talked about at the beginning, we're not seeing the agency move rapidly to use these reserved visa numbers. So more numbers are going to the unreserved older cases, and in some respects, that's fair and good because those people have been waiting a long time and we want to see them move forward. But we're going to have to see, and we're going to, we'll see some indication, some signs of where we are over the next 6, 12 months, year or two, of how quickly the dates are advancing, the visa bulletin cutoff dates are advancing for these unreserved categories. It could take 3 years or 5 years, it could take a little bit longer, but we do expect to see us move through that backlog in the coming years. And that's going to provide, at that point, almost all of the cases that are pending will be post-RIA reserve category cases, and they'll have access to all of the numbers, not just the reserve numbers, but all of the 10,000. And that'll be a really wonderful thing to see those visa numbers become available and people start to get their green cards from the post-RIA period.
Yeah, I think from now until September, the market is really going to take off.
Right.
Yes.
We have a lot of people here, even in the United States, in different visa categories who've been thinking for a long time to maybe participate.
Like transfer from H-1B.
That's right. H-1B is one of the big categories. So I think we're going to see F-1's another big one, yeah. So I think in the next few months, we'll start to see a major explosion in terms of demand within EB-5.
Yeah, for those young folks, most of them they're single or only, one spouse. They don't have any kids there.
That's right. Yeah.
Yeah, it takes less visa numbers in the future, maybe. Yeah.
And another thing is that in the last 4 or 5 years, I think AOC they made a very, very good decision to push the rural projects. We both understood that after the RIA, the rural projects has a priority, no doubt.
Yeah.
However, there is some news from last week, and I think the priority of the rural projects is even enlarged. Could you please give us some advice on that?
Well, I think
what's really changed last week?
I think he's talking about the FIFO thing.
FIFO,
Yeah.
Sure.
So the 2022 law, the RIA, includes a provision that says petitions for rural projects will get priority. And that's pretty much the sum total of what that provision says. And until last week, USCIS had not explained how they were prioritizing the rural petitions. We know they were because we've seen them move to adjudication more quickly than HUA and other petitions. But we hadn't heard exactly how they were doing it. And so what they put on their website last week in a question and answer provides a bit more information. I wouldn't say it's entirely clarifying or enlightening, but it says we are prioritizing these and we're putting them in order, but we're also going to look at visa numbers and availability, and we'll start to put in other petitions as well when we've reached enough rural petitions to get to that.
I saw that too. It's like, it's very interesting that it says like when we reach the enough number, how do you define the word enough, you know? Either they're gonna digest all the rural petitions or they will move to the HUA petitions when they think this is enough. I mean, I'm pretty sure nobody's gonna know like the exact number.
That's right.
But it just make me feeling like, oh wow, okay. So
yeah, they gave us that indication of how they're managing the program, but from the inside, you know, how it's actually playing out, there's a lot of questions there. And I think the next 6 months, as we see more demand, we'll start to get a sense of which categories are moving faster. Right. But what I think will remain a constant is there'll still be demand for rural projects on the market. And, you know, that's something here at ALC that we really specialize in.
That the Q&A thing came out, it really helps us because we've been telling the investors or the potential investors that only rural gonna, you know, let you get the green card faster than the other two types. Now we know that the USCIS that they will do the rural petitions first and then HUA and then infrastructure, which proves that we in the past 3 years we never got any approval on the infrastructure, either HUA project.
We have seen approvals on HUA projects, right, Jin? But just much slower.
In the marketplace, for sure, people see an imbalance. The pre-RIA investors, they are still in the decade-long backlog. They are still waiting in the long queue. And for the new investors, or shall we say the post-RIA investors, they are sprinting with the new policy, with the new rules. Right. As a formal officer in USCIS, how do you see this kind of imbalance?
That's tough. I mean, that's a hard one. I think that the new legislation was very necessary, and to try and fix a lot of the problems that were within the program, right? And so I think that's been a success. What's difficult is to try and bring those same set of requirements and apply them to those that applied under a different program. So you are still, unfortunately, going to have that lag time for the pre-RIA investors.
What is your opinion, Gary?
I think there are rules in the RIA that the agency must follow. For example, priority processing for rural projects. And that means that some individuals who are filing much more recently are going to, be able to get their permanent residence, their green cards, before others who filed much earlier. And I think that might offend in some ways our basic sense of fairness. But it's also important that the agency follows the rules in the new law. And so it's a balance, and one that might have some unintended consequences in some ways.
Before we say goodbye to our audience, I would like to have all of you give a piece of advice to advise our audience how to utilize this grandfathering clause.
So look, EB-5 immigration really is a journey. It's a complicated process, but it's a journey that you don't travel alone. So what I recommend is if you're really considering moving forward with EB-5, build your team. You need your broker, your agent, your attorney, and critically the regional center that you want to work with. And if you're considering EB-5 now, you've got a few months to still take advantage of the grandfathering clause, which is a huge protection. So I encourage you, if you want to move forward, now's the time to really look at building that team, putting the application together, and moving before that September 30th date, because that puts you in the strongest position to succeed.
Chris and I both come from immigrant families. Chris's parents immigrated from Great Britain. My grandparents immigrated from Eastern Europe. And I always think to what kind of a decision that had to be to make that change and want to come to America. And it's a huge decision, and there are many different factors that are in play. And as I said earlier, you're uprooting your family. It's a new country, new customs, a new language. And so I would never rush that decision. People have to make that life decision at their own pace. But once you've made the decision, pick your partners and move forward expeditiously, thoughtfully, carefully, but quickly, because a short delay now could lead to a several-year delay down the line. And you want to take advantage of the protections afforded to you in the 2022 law. So that's grandfathering and concurrent filing and all of these things that make the process just slightly better for you, rural priority processing included. And then begin the journey. And we look forward to supporting those who choose to do so with ALC.
Thank you.
Exactly. So I really appreciate that we had a meeting today that gave answers to a lot of potential investors or even the existing investors that for like how am I going to be protected by grandfather law, or is the potential age out thing going to affect my children, or am I going to be affected by the potential backlog? Now today we got answers, and then I would always suggest or recommend you guys, like in the future, you might, whenever you get questions, don't go to the some other like social media, red note, find out those blurry answers. Always gonna come to the authority, regional centers, or go to your law firm, or you want to talk to the broker dealer, the agents. Always get the precise answers before you make the final decision.
For sure, a EB-5 investment will be a huge decision for any family. I agree with Gary. Don't be rushed. However, if we could smartly take the expertise from the professionals, you will not be alone.
That's right.
So in the future, it will be an administrative formality rather than a life-changing delay.
That's right.
And as Gary just rightly mentioned, if we can make a correct decision, the reward will last in a lifetime.
Lifetime, that's right.
Okay, we will be keep updating from Washington, D.C., even they have that kind of inefficiency.
That sounds great to me, yeah.
Okay, thank you very much for joining us, and let's say goodbye to our audience together.
Yes, sure.
Thank you.
Thank you, bye-bye.